What is up, Lord? Welcome back to Truth and Transparency. It is a Friday night. I told you guys I was going to be kicking it with you. We got the new unsealed documents in the Idaho versus Bryan Kohberger case. We're going to be talking about those, and we're going to show you something, though, first. 4 minutes and 32 seconds.
Bryan Kohberger's cell phone. I want to talk to you about
the physical cell phone or the data from the cell phone.
We're going to talk about both of those. Okay. So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Bryan's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
copy
warrant?
Of Bryan's cell phone.
Again, I'm asking which search warrant you're talking about, the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized. So it'd be the first.
The Pennsylvania one?
Right.
I do not know.
Unsealed and unredacted. The state's response to the defendant's 23rd supplemental request for discovery, Exhibit V. The question is, request 438, complete copy of the chain of custody of the Samsung phone item 902 belonging to Bryan Kohberger. Okay. The state says, now this request was made, this is one of the new unsealing items. This request was made on June 2nd, 2025, due to the report that the Barnharts made. Okay. And it said, the state responds the next day on 6/3 and says that the state has already provided and the state has previously complied with this request. But here it goes. The laptop is identified as item 905, and the phone is identified as the other one, 9090, whatever, 43. They're back to back, 902 and 905. Okay. And the chain of custody is as follows. His phone. Bryan Kohberger's cell phone was seized from room M in that house, at his parents' house, 119 Lamson Drive, on December 30th, 2022, by two different FBI guys, not Tanzola. Then, somewhere when they were on premises, these two FBI guys, Schwerer and Brunn, give Tanzola the phone. Tanzola then transported the item to the Philadelphia Regional Computer Forensic Laboratory, to the PHRCFL, that's what that stands for, Philadelphia Regional Computer Forensic Laboratory, and the evidence control room. On February 11th, Special Agent Tanzola took possession of the above item. So Mowry never went to Pennsylvania. So Mowry never saw Bryan Kohberger's phone. Also, there's not a warrant that's saying that you can get into the phone yet because they did not type this up until after the fact. So on December 30th, okay, it is seize the items. That's it. On February 11th then, so like a month and some change, Tanzola took possession then of the above item, the phone. This item was hand delivered to Detective Mowry. And then on July 22nd, 2024, so a whole year and a half almost, Detective Mowry transferred the above item, the phone, which had been secured in the Moscow Police Department forensic lab, and booked the item into evidence with the evidence custodian at MPD. Now, a copy of the image, which means the image of the cell phone, was labeled as QPH5 hashtag 1 or underscore 1. And we'll go into that because that doesn't matter. That's about the laptop. But now listen to this. Listen to this fucking testimony.
Aware that a copy of the phone was made and put on a USB.
Yes.
And then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No.
He just said no. How the fuck do you know that? You're not in Pennsylvania. Where was the extraction done? Listen to this. This is absolutely, now it's all making like, oh my God.
And how do you know that?
I was the one that received the extraction.
Dude, he like literally answered that with a straight face. Like, these motherfuckers are dumb. They're dumb. Dude, well, no, nobody searched it. Wait, how do you know that? Well, because I was the one that received the extraction. Where was the extraction done? In Pennsylvania. The FBI did the extraction. How do you have to perform an extraction? And that's where I think Mathis is needed to like literally hand feed and spoon feed it to these judges to break it down like second graders. Okay, an extraction. Don't you physically need the phone? And then what do you have to do? How does one extract the data? And then how would you know? So then the data gets put onto a USB or like a, a bigger storage box. And then how do you know if somebody actually plugged it into their laptop and actually went through the extraction? Now, this is what we're getting into with the leaking of Bryan Kohberger's cell phone. So how would you know that nobody searched the extraction if the extraction was done in Pennsylvania and you are in Idaho? How would you know that? You wouldn't. So I'm just like listening to this answer like, wow.
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
Wait, what? Do you guys understand what the question was? How do you get the Cellbrite, or how do you get the extraction to you? Because it goes onto a USB. So like, how would you get that product? Oh, it's through some Cellbrite tool. What? No, like, did he physically give it to you? Was it FedEx? Like, how did you get the extraction? I mean, are these people dumb? I need to know. I need to know. Does everybody understand that question? I think, I mean, wow. She's like, what?
So what about is the USB not a physical box of the extraction, or is it all digital?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Yeah, explain that.
Normally
right there. Normally. We're not fucking talking about normally. In this case, she lets him talk.
forensic environment, the device is extracted, that extraction, and then therefore replaced onto a different storage device. for evidence storage
How does an extraction happen? What does the word extract mean? I mean, that's what, like, she has to literally break it down like this.
or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
The data was placed on a storage device by SA Tanzola and provided to me.
Okay. Now, you're like, Lana, why are you playing this? Because of what just got unsealed. If you go to, it's batch number 1, item 42. And on 6/2/2025, 6/2, 2 months before trial, the defense is asking one more time, can the state please give me a copy of the chain of custody of Bryan Kohberger's cell phone? Okay. And what he just said there, he was not in Pennsylvania. Okay. And what he just said there and what's on here is not the same. Nowhere does it say that Bryan Kohberger's phone was extracted in Philly and that there was his phone and that there was a USB or a storage device, okay, and that those made their way together with Tanzola from Philly to Moscow. Because it's important when you find out when they filled out these search warrants, everybody knows, and if you don't, I'll be happy to tell you, you cannot just look at someone's phone or possibly know what the IMEI number is. How would you know what your IMEI number is unless you actually got into the device? If the device is in Pennsylvania, okay, and the device stays in Pennsylvania until it is physically in Idaho, not until February 13th of 2023. How do you write a warrant if you are in Idaho on January 3rd or 4th and writing down what the IMEI numbers are? How would you know that? There's only one way. That would mean that the people, aka the FBI, when they had the phone in Pennsylvania, they were in the phone. No other way for you to possibly know that.
How did you get the storage device?
I believe it was brought back. I don't recall.
How did you get the storage device? I believe it was brought back. I don't recall.
How I was given to it. It was still in the FBI packaging.
The prosecutor says Tanzola personally hand-delivered this to Detective Mowry.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Yeah, in the phone. I know that.
Okay.
You guys know.
Judge, this is when you don't have yet either. I apologize.
He goes to the item.
The document on which the sticker is placed. First page is affidavit for search warrant. Directed to the Moscow Police Department Forensic Lab.
Of the cell phone of the USB. Did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
Guess I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but it's not, this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the Digital Forensic Lab.
Mhm.
So there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Mhm.
Can you turn to page 24?
This is so good. This is so sick.
You see that page?
Yes, ma'am.
And is that page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
Nope.
No, ma'am.
On page 20,
Okay.
January 3rd, 2023,
Okay, ready?
on January 3rd, that January 3rd, 2023, that warrant asked for Bryan Christopher, 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Oh! Oh my God, you sick son of a bitch. Boom. Lana, break it down for us. Is that right? Okay, ready for this? This is crazy. Absolutely crazy. Okay. Maury, he's in Idaho. FBI, Brian's house, Pennsylvania. Okay. They take his phone December 30th. They have it in Pennsylvania. Maury is not in Pennsylvania. He is in Idaho. Okay. Everybody testified that nobody got into and searched into Bryan Kohberger's phone prior to actually having a warrant to do that. Okay. So the question is how in the fuck did Maury know what Bryan Kohberger's IMEI number was? I don't recall. And this is where Elisa's Mathis needed to go more into it and say, okay, well, let's talk about this a little bit. Where is that located? Wouldn't she physically have to be with the phone to possibly obtain the IMEI number? But she's over here assuming that Judge Hippler gets it. Okay, do you understand? So Lawrence Maury is saying he's writing up this affidavit on January 30th for a Google search warrant. Okay, a Google search warrant. It's all Maury over here. Okay, and here you go. So I'm gonna back it up for everybody.
Bryan Christopher warrant in this case. Well, isolated to this case.
No.
You've done Google warrants before.
Oh, yes.
Oh, yes. Okay, great. Awesome. Here we go.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Brian Christopher 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Okay, now I have a question for all of you guys. Judge Hippler, he sits and he's done so many cases, right? We think he has to know what that means. He doesn't know what that means. He doesn't get it. She needed to break it down and to say, okay, where's Brian's phone? Where is that located in a phone? Like you told me what the acronym meant. Okay. Now, where is that found? What does that mean? How did you get that number? What is that number? How is that specific to this warrant? Is that Brian's? Is that from Brian's phone? Okay, you're in Idaho, right? Is the phone in Idaho in January on the 3rd? Who has it? The FBI have it. Okay, and that you said that they didn't go into the phone, right? This proves that they went into the fucking phone. Or that they looked at the extraction. This is unbelievable. You're going to sit here and tell me that Hippler needed it to be broken down like a second grader? It is impossible, okay, for Mowry to have this number. Impossible for him to have this number on January 3rd, 2023. Impossible. The only way you could have this number is if somebody already got into the phone. The only way. They didn't have a search warrant yet for that. And that's what happened in the beginning of all of this to talk about, well, how do you know that nobody got into the extraction? How do you know that nobody got into the phone? Well, were you in Pennsylvania? No, but I got the extraction. So nobody else got what are you talking about? The extraction's on a USB. Anybody could put a thumb drive in. And what an extraction is an Excel spreadsheet, basically. It's just a PDF. I mean, it's a PDF, and it's the image of Bryan Kohberger's cell phone, which is literally, it is the special investigation is all about this. Why do you think he answered, I don't recall? You don't recall how you got that number? To put in your warrant in January 3rd. She's like, okay, wow. And she's over here thinking Hippler gets it. Look at him.
Get that number to put in the January 3rd, 2023 Google warrant.
I do not recall.
He doesn't move. Unless this is like specifically outlined in this brief, okay? But you would need to break that down for him.
Okay.
But she thinks that she's done a good enough job. Yes, thank you, DB.
Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support.
From Google. Appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific.
It is now perfectly clear when you go through the Moscow Police Department's reports for me. And I'm like, why the fuck where are any of these reports? Why are these reports not being done? What the hell's going on? Where are the reports? What are these people doing? Dude, they cannot document the shit that they're doing that's not on the up and up. That's why there's no fucking reports. Guess what I did today? I was on the phone, or I was emailing with Google, figuring out a way how we could bypass and get the sales to work with us and yada, yada, yada. Did you guys see that in any report out of the 314? No. Sure didn't. Wow. Just wow. All right. Again, based on the Barnhart's report, Ann Taylor resubmitted Defense Supplementals 23. She resubmitted this shit. Okay. And she wanted the exact chain of custody. Because he gets asked on this stand who had access to it's bizarre.
Warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was they couldn't do it because there would be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Well, there's reference to
how can you literally get on the stand and say that you don't know the difference between a personal account and a not personal account?
To DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Yes, you do. How can you literally say that on the stand?
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay.
What is it?
And that email address associated with the defendant is a college that he attended, right?
Yes.
And so what was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did.
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with
No,
that?
ma'am.
How does Judge Hippler look so not interested when literally we watched it in front of our face? Now that you have this material, okay, and you actually watch this with the material, it's like, what? Unbelievable. Let me show you guys something. There's a question he gets asked about page 24 of the search warrant. Any reference to the affidavit or it had to do with the cell phone? He's like, no. Then we get asked about this USB and who had access to it, because this is what this leak is all about.
The timeframe of January 1st, 2021 to December 30th, 2022.
So she's asking him, why did you put the years 2021 to 2022? Like January.
I don't recall the specific reason why we went back to January 1. It was to include the time that we believed that the defendant had entered Washington to become a student nearby the crime scene and just prior to that.
But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review?
How can you give an answer like that? And then you know that, but you knew that he didn't get to Washington until June of or July of 2022. And he just admitted to, yeah, we knew that. So what is January 2021 to all the way until the 2022 date?
The Google warrant return emails?
Yes.
You designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators.
Okay,
And
let's-
Evaluating those. You said you reviewed them. Are you the one who's until June of 2022, right?
correct.
Did you review the Google warrant return emails?
Yes.
Did you review? So you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
Okay, right here.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate? That makes sense now. I thought it was the name.
I believe that Special Agent Michael Douglas assisted in service of those. I
come
don't
up
remember the exact way that I did it, but it's
in that descriptor?
a forensic lab. USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by key in the computer forensic lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data
It
was
would be Bryan Kohberger's phone, who ultimately was responsible for searching. Now, the Barnharts were saying that this is what would be in these returns from his phone is what he's Googling when they're talking about this porn and shit. Okay. Everything that Nancy Grace is talking about, everything that all these channels are talking about, and that the Barnharts have testified, or not testified, but have come out saying we searched through all of this stuff. Right? Listen to this.
extracted.
This USB, he is saying, has been in a locked. Okay.
Placed into by myself.
In that descriptor?
Oh, ma'am.
Can you turn to page 28? Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by key in the computer forensic lab.
How did the Barnharts get a copy of this in March of 2023? What did the Barnharts get a copy of? Nobody got into the extraction. The extraction was just brought to Detective Mowry from Pennsylvania in February of 2023, and that is where it stayed, in a fucking secure locked box in Idaho. You'd have to make a copy of that. How many copies did the FBI make?
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Who? Listen to this.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
Oh,
know-
so the FBI, they had it. They examined it. You guys, what's on this material? You guys talking about those photos, those pictures, how people were getting selfies, why there was this leak, okay, and everything that stemmed from this huge leak. All right, this is it right here. FBI did the extraction. The extraction on the cell phone, but in the chain of custody, they never even talk about this extraction, but they just talk about the cell phone, that the cell phone makes its way down over to good old Mowry on February 13th or 14th of 2023, and that it stays in a secure lock box in this one single room, and until he puts it into evidence with the MPD so that it could be actually accessed by the defense, not until July of 2024. Okay. But the Barnharts, they came out saying that the FBI got in touch with them in March of 2023, to bring them in on this case. They don't write up a report though until, and it wasn't like Moscow hired them or Latah County or FBI March of 2023. FBI doesn't have anything. I thought that they'd transport everything. Here you go. Then Maury just says, well, no, the FBI was going through it. Wait, what? Who had access to Bryan Kohberger's cell phone shit, which is the extraction material, which has all the data, which any picture that's on there, it would come and look like it's just scrolling on like a PDF and you're just going through everything that's in his phone.
Also given to the FBI. The FBI had that information and they examined it.
And do you know who with the FBI?
No, I do not.
This man answers a question, and
You said you don't remember all of them, but who else do you remember?
listen to this answer.
Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
And do you know who with the FBI?
What do you mean the FBI was given that information? They weren't given it. They took it. They had it from jump. What the fuck is he talking about? What do you mean it was given to them? Didn't they do the extraction? But you told me that nobody got into it. See, she's not breaking it down for what the purpose is of this, which is a suppression hearing, okay? And she's not breaking it down so that obviously Hitler can follow along to say, okay, you just told us 10 minutes ago that nobody got into the extraction because it was brought to you, and I just asked you, had anybody looked at it? Like, what the fuck are we here for?
No, I do not.
Hitler, the only way that you're getting warrants is because you get new information, because you're writing up the next. How are you keep getting these warrants? Because you're finding new stuff and then, okay, hey, I'm going to apply for this. I'm going to do this. I'm going to do that. Hitler, if you have questions, if you're not following along, you can ask. I don't understand how he doesn't get it with all the material that we have right now is what he had. These are the exhibits.
Can you turn to page 27?
This seriously is pissing me off. Because this is corruption in front of our faces.
Can you look at page 6? Or not page 6, I'm sorry. Number 6, line number 6. Do you see that? What does that say?
Copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about
Ridiculous. Fuck these people. Okay, so let's go like this. At the end, very end, we find out Maury lets the cat out the bag and says, well, the FBI has their own stalking investigation going on.
One, it was to include the time that we believe that.
let's talk the final area in that warrant. Sorry, not thorough. Refresh your recollection regarding what communications were occurring.
Right here.
Appears that there was communication between Apple and FBI.
Apple and the FBI.
And were you included in that?
I believe I was.
Okay. And did that include chats?
I believe the word chat means to chat, to talk.
Like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation, as I stated in my email there for the stalking investigation.
Boom. The FBI's current investigation into the stalking.
I was merely just privy to their conversation.
So so you guys want me to believe that the FBI is including this fucking idiot into the FBI's business with what they're doing for their investigation into something else, which is the stalking part of it that has nothing to do? They're going to include this man?
Have all of their materials related to that been turned over?
Who's there in that sentence, Kelsey?
Pardon?
Who's there in that sentence?
Sorry, FBI.
Are you serious, Hippler?
I do not know. I wasn't, I don't know.
You see how he almost slipped there? I wasn't privy to that. He caught himself. Wait, Mathis says, okay, so you're involved in this, like they have you in here. Okay, so they give you information about their stalking investigation? Listen to this.
Have all of their materials related to that been turned over?
Who's there in that sentence, Kelsey?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
Did Kaylee, did somebody report somebody for stalking them? How are these people going to take the stand? They don't know anything. He doesn't know shit. All right, here you go. So, oh my God. Supplemental, this gets turned in. This is just unsealed. This is the 24 supplemental request for discovery, Exhibit W. 441, 442, 443, 444. And Taylor is saying, can I get a copy of all arrest reports, charging documents, and videos for Molly Marie McMichael from June 1st, 2022 through May 31st, 2025. She's asking for this on June 25th, 2025. Go look at my videos that I dropped from 6/19 to 6/25. It's 442. Copy of all email communication between the Goncalves family, it's Gonsalves family, their attorney or representative, and the Latah County Prosecutor's Office relating to Molly McMichael. Ready? Copy of all 443. Copy of all email communication from the Latah County Prosecutor's Office and law enforcement and or other agents relating to Molly McMichael. We want you to put her name in, and we want any communications back and forth between y'all about Molly McMichael. 4. Do you want to know the date that they get this back to Ann Taylor? July 9th. You guys know how long, like what July 9th means, right? It's after already the deal. Remember when I told you guys, I said, what the fuck? I said, why is this dropping right now? I said, this has just been around. And then I said, of all people who put it out, I said translucent. Translucent. This person who's making vile fucking videos about like Kaylee and Maddie being like essayed by Steve, shit like that. And you want to know what one of the best trolls in the world ever told me? You need to troll yourself if you want to fucking keep people off your shit. You need to troll yourself. The translucent channel is all AI. It's somebody that's very, very good with AI. Very good with AI. And I was like, how the fuck? And then I was like, well, who's this body cam person that made the video that makes all these Washington videos? They started the channel during this pending case in 2023. I want to say like the summer. You guys can go look up that date. Yeah, that the body cam had it out first. Not sure how she got it. No, she used theirs and she just copied shit off of it and shaved it off of it. But the person who actually made the video, that body cam channel, I said they didn't just upload the body cam and just let it play all the way through, therefore possibly then giving them a possible out to say, I didn't even know it was on, I just always upload different things. No, this shit was specifically cut and edited, and so therefore somebody would have went through the video. And if anybody knows, in your, like, this case is huge, you would hear about this and someone saying, oh, I'm the DoorDash driver and I saw Bryan and shit like that. That person knew exactly what that meant. And that person, I think, has a really good relationship with the Latah County prosecutor. And they kept their fucking mouth shut. That's what I think. But then how did trans motherfucking Lucent all of a sudden pop, poop, she just goes across that body cam, finds that, and then puts that shit out there at a very interesting time. Well, Steve's telling Bill to go fuck himself. Bill responds with those questions. The state responses are provided in blue. So this is the date that Ann put the request in. And everybody was like, why did she put a discovery request in? And she's literally going to tell her client to take this plea deal, right? So it was asked for on 6/25, and I believe it was supplied. The date I have is 7/9. Unreal. And Bill says 441, copy of all the arrest reports, charging documents, and videos for Molly Marie McMichael from June 1st to May 31st of 2025. So during this period. And the state has complied with the video portion of this request and has provided the following. So that's the body cam. And look at, they're trying to say that the first date that they discovered it was on 7/7. The Latah County Prosecutor's Office is trying to say that we never even knew that existed, and the first time that we discovered that existed was on 7/7/25. And they think that they work hand in hand with Pullman. I mean, this is sick. This is absolutely sick. And then, she asked for like arrest reports, charging documents, right? Then the next question is 442, which is the state has requested the balance of this request and will discover upon receipt. So they're still waiting for that, they say. Then on 442, copy of all email communications between, and And I'm like thinking, why is Anne asking for the email communications between the Gonsalves family, their attorney or representative, and the Latah County Prosecutor's Office relating to Molly McMichael? The state has complied with this request. The state reserves the right to object to further disclosures that are outside the scope of the above request pursuant to, and it's 16.3G. So here's what they're saying. Hey, we're going to comply with this, but we're not going on some rabbit hole or whatever, And they're saying these are the Bates pages. And if you go and check stuff out, I think this is going to be at the way, way tail end. And it's emails from Steve on 6/19/2025. And then email from Shannon Gray on 6/16/2025. And it's like the first date that you're discovering this is on 7/7/25. You're telling me that when they wrote you the emails on 6/19, you didn't, and 6/16, you didn't open them? You didn't look at them? You didn't know that they existed? Do you guys understand what I'm saying here? I'm saying that Steve emailed the prosecutor. He did it on 6/19/2025. Shannon Gray emailed the prosecutor on 6/16/2025. So one of them did it on the 19th, one of them did it on the 16th. Okay. The prosecutors are like, we just on this same day, we are giving this to you. So 2 days prior to this, which was after you actually, though, like you requested it, so it made us go hunting, I guess, for this. You didn't know that. Like, how could you say that you discovered this email on this day? You don't open up your emails from the victims' families? This was during I don't even know what to say. 443, copy of all email communications from the Latah County Prosecutor's Office and law enforcement and other agents relating to Molly McMichael. The state objects to this request as it is exempt from the disclosure pursuant to 16.3G. Why is it so hard to cuff up whatever emails you'd have with Suge Tits? I want to read off the ICR really quick to you guys, what he wants to cite. Okay. G. Let's see. It's just, they're saying it's just not. Yeah, it's not going to happen. Hold on. I was seeing if it was under informants. Because there is under like informants disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or a trial, subject to any protective order. But that wasn't it. I don't think that is that. I'm looking under G. G is the prosecution information not subject to disclosure is work product. Disclosure must be required of legal research or records, correspondence, or reports or memorandums to the extent that they contain the opinions, theories, or conclusions of the prosecuting attorneys or members of the prosecuting attorney's legal staff. 2 is informants. Did they put down the wrong fucking number? Or wait. Yeah. No. Anyways, going back to the whole fucking Molly situation. They asked if basically, well, since Molly would have made those comments, right? Did you guys ever, interview her again to say, what the fuck is this that you're speaking about in this body cam? And they said they have not spoken with Molly. Any updated supplemental reports and or recordings of interviews conducted by law enforcement with Molly McMichael. The state has requested this information and will discover upon receipt. Well, we have 314 reports here, and none of them say that they ever talked to Molly McMichael again. Okay. But what I find hard to believe is copy of all email communication from the Lathrop County Prosecutor's Office and law enforcement and or other agents relating to Molly McMichael. And if you go back to that live I did, I said, if you guys think that Molly McMichael had her first fucking interview with Detective Payne, y'all are smoking fucking crack. Because, well, again, thanks to what we got our hands on, what we just got approved for, is I said, I want Molly McMichael's audio and video recording with Detective Payne on the 23rd. And so we got approved for that. And I'm like, thank God. Like, Thank God. So Moscow got back to us and based off of the way that Blaker writes reports, we have no idea what to fucking expect. Who knows? But Bill's like, we'll go ahead and we'll ask the state. We'll ask the cops if they have anything. So we don't have anything though. I can't believe that she wasn't keeping tabs. I can't believe that Ann Taylor was not keeping tabs on Molly McMichael. I mean, I was shocked. So back when this was released, or when this was item 38 that was unsealed from batch 1. This is one of the new ones, and this is the motion for independent analysis of evidence. Guess what it has to do with? Very, very important piece. 2 pieces here is his laptop and his phone. And I'm telling you, it's because of this was put in June. June 6th. Dude, trial is like 7 weeks away. 7 weeks away. I couldn't even believe it. Comes now Bryan Kohberger buying through his attorneys of record and hereby requests the court for an order allowing an independent test of the evidence which relates to the above entitled matter and is in the possession of the Moscow Police Department, specifically his Acer laptop and the Samsung phone belonging to Bryan Kohberger. And I was just like, they didn't do this sooner? Like, I'm kind of shocked, right? Or what's making them want to do this now? Like, what? And I'm telling you, it's all because of what the Barnhards put in their freaking shit. It says that the items requested should have a continued chain of custody from Moscow Police Department to the defense expert. So she's saying how she wants it done. And this is whoever the expert they were going to give that to. The item shall be hand delivered or sent via FedEx shipping to blank and returned directly to Moscow Police Department through FedEx shipping. If either item of evidence is damaged or lost during the transportation of such items, the defense will stipulate to extractions done by the state and or photographs of items. They were like, no, fuck this. Something's up. Something's wrong. And it has to do with their report. It was whatever the Barnhards put in their report, which is being spread all over the fucking community right now. The defense was saying that there's something wrong here. But what I think is just crazy is that trial is literally like 7 weeks away at this point, and they don't even have anything. They don't even have the item yet. This motion is made on the grounds that Mr. Kohberger has a constitutional right to confront the state's evidence, conduct an independent investigation, and prepare and present his defense in his jury trial. Then Ashley Jennings responds and says, this was unsealed, item 34, which is the state's response to the defendant's motion for independent analysis of evidence. And they're saying that comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully informs the court the state does not object to the defense's motion for independent analysis of evidence so long as this analysis is not used as a basis for a motion to continue the trial. The state notes that the defendant received the extractions, the digital copies of these items on April 4th, 2023. The Barnharts had them on March of 2023. The FBI hired the Barnharts. Moscow Police Department did not give the Barnharts the shit. The FBI did, pertaining to the laptop and the phone. And then now here's Hitler's order on that. And Hitler's order came down, this was unsealed, on 6/9. And the court having before it the motion for independent analysis of evidence and good cause appearing now, therefore, it is hereby ordered that the aforementioned evidence shall be made available to the defense expert blank by Moscow Police Department and or other agency in possession of the same for independent testing and review by an independent testing agency. It is further ordered that blank, who this expert is, shall at the defense counsel's expense be allowed to conduct the independent testing of the evidence. Specifically, the Acer laptop and the Samsung phone belonging to Bryan Kohberger. And then how the chain of custody will work. It is further ordered that the results of the testing shall be considered work product of Mr. Kohberger and or his attorney, and said results shall be submitted solely to the office of Ann C. Taylor. Duh. Okay. Now this is what took me for a little loop here. So Bill Thompson on June 12th, 2025 hits up the courts and says, comes now the state of Idaho by and through the Latah County prosecuting attorney, and respectfully moves the court for permission to amend the state's witness list and to supplement previously filed expert disclosures by adding Dr. Christian Westring as a potential expert witness. We went over this yesterday and I was like, this has to be a rebuttal. Okay. No, he's in their case in chief. And I said, wait, what? The state makes this motion to add the above referenced witness to testify about an issue that the state believed had been resolved. Namely, the defendant was found not to be a contributor to a DNA mixture found under one victim's fingernail. The state proposed a stipulation to this effect, but defendant informed the state that he will not so stipulate because he prefers to present testimony about this fact. So listen to this. They were like, listen, we'll stipulate to all of this. Jade Miller will just testify and she'll say this specific language. Okay. And it will basically show that it's excluding Bryan Kohberger. Like, that's what they're making it seem like to me. And then I think Anne and her team are like, we don't trust these motherfuckers. What if they just, what We have no idea what this broad's going to say. We can't trust them. If you could trust them, then you would, because this doesn't make sense to me. So in this writing, they're saying we were willing to stipulate to that the mixture underneath the fingernail of Maddie, that DNA, Bryan Kohberger is excluded, right? That is absolutely correct. They do not, and it's in the wrong order. It's something's off there. Something's missing. I didn't want to sit there and explain that to everybody, so I just moved on. But that is absolutely correct. So I'm like, okay, wait, what? So it prefers to present testimony about this fact. Thus, the state will likely need to call Dr. Christian Westring to testify about the DNA mixture so that the jury can understand the state's position and not be misled into believing that there is factual dispute where none exists. And I'm over here like, wait, you guys are calling somebody to the stand in your case in chief now, or will you want to, that's going to say that Bryan Kohberger's DNA isn't under the fingernails? Like, then what's Jade Miller testifying to? I'm like, what? On February 24, 2025, defendant filed a quote unquote motion in limine number 5, inconclusive data. Yes, we all saw that. And this motion centered around a DNA mixture found under victim Maddie Mogen's fingernail, item 13.1. And the Idaho State Police Forensic Laboratories ISP lab conclusive that it was inconclusive. What the fuck? And conclusive that it was inconclusive whether defendant was a contributor to this mixture. As Dr. Westring explained in his affidavit, see below, that conclusion is a result of limitations imposed on ISP lab staff by certain internal policies. But the state did not intend to argue or imply that the defendant was a contributor to the DNA mixture, and it has maintained this position since the issue was first raised. And I was like, oh, okay, now I get it. So the defendant is like, no, we're not stipulating shit. We're going to have our person, and when we call this motherfucker to the stand, they're going to talk about what the fuck is up. Because whoever they used was able to rule him out in their way that they did it. And now all that Christian is basically going there to testify to is that nothing was hanky with Idaho State Police and how they do this portion. This is how they normally do it. This is within their procedures and regulations and blah, blah, blah. But how this is being presented in this write-up is very interesting to me. It's like a this is not how law is supposed to be. This is not how justice is supposed to be. These are lawyers. I'm sorry, but Ann Taylor has 3 people on her team, right? Ann and her team of 3 people, including herself. I mean, if you want to include the investigator, whatever. But I'm talking about lawyers that are sitting there. They were taking on it was like David versus Goliath. There is no way that Bill Thompson wrote this. He can say all day that he wrote this. There's no motherfucking way that this man wrote this. This is not how Bill Thompson writes. Go read his shit fucking 3 years ago, 2 years ago. This man is a hothead. This is wrote in a way that is like, it would lead the reader to believe that, geez, God, they're just, it's all tricks and pony shows, and this is just the, the defense is doing some like smoke and mirrors or something. Like a former AG wrote it. Bill Thompson didn't write this. There's no fucking way. Bill Thompson signed it. Sure. Awesome. He didn't write this shit. No way. I'm sorry. I have no problem saying it. Hey, the only reason that we have to call this guy in our case in chief, which is like these expert disclosures were supposed to be like so long ago. And Hitler's over here like, yep. But Ann Taylor's over here like, we have no issues with it. And I'm over here like, wait, what? I don't think that this guy should have been fucking able to testify. Hey, you guys have your stuff and we have our person. But they're making it seem like, oh, I thought we had stipulated this. Now they want to say that we're not stipulating. And so because they pulled that, we need to have this person. And it's like, what? The state proposed a stipulation to this effect, but defendant informed the state that he will not stipulate because he prefers to present testimony about this fact. Well, I'm sure that this would have come up a long time ago, right? I don't understand. So yeah, this dude is literally would be testifying to the fact that, hey, guess what? Idaho State lab staff, they're great, and this is how they're supposed to do it, and it's all done by the book, and blah, blah, blah. Like I talked about the other night. So thus the state retained Dr. to review the DNA testing and the computational analysis of the data in response to the defendant's motion on April 7, 2025. The state filed an affidavit for Dr. Westring attached as Exhibit S1. In summary, Dr. Westring opined, one, that there is no published standard that dictates how to determine analytical thresholds. Two, ISP Lab concluded that the analysis was inconclusive with regards to Bryan Kohberger in accordance with their published standard operating procedures. And three, based on Dr. Westring's independent analysis, Bryan Kohberger was excluded as a potential contributor. And I'm like, do you know why they're doing this? Because it matters this much about the goddamn DNA. The DNA is everything in this case. That was the touch DNA. Okay. And they cannot let anybody go into that courtroom and give those jurors a reason not to trust something that the Idaho State Police Lab did. And that it's like, hey, no, everything that they did was correct. That's the right way they were supposed to do it. Okay. But I even went one step further because what I do is different. And when I do my stuff my way, yes, he's excluded. Why the fuck would you ever call? Why else would you have this? That person was set that Ann Taylor was going to use was going to make them look incompetent is why I see this man would need to testify. That, hey, based on the way that whatever the test was that she ran, the likely ratios, and that, hey, all of that is standard. They didn't do anything outside norm. They did everything to their procedures and protocols. I then can run an extra test to do it this way, and yes, he's excluded. So, because Bryan Kohberger, they were going to have their person be testifying to saying that they excluded him, and they don't want the jury to feel like that they were bamboozled, okay, during the course of this investigation and with the name Bryan Kohberger and with this, how they presented to the grand jury, if they could possibly have been brought up. Like, you testified at the grand jury, didn't you? And this is what you said, right? Just like they did in the Karen Reed trial. Like, but I would be thinking, I'm like, wouldn't this be a rebuttal though? No, Bill Thompson's like, no, we need this to be our due with our case in chief, because I'm like, wait, so you're going to try to get in front of something? How was that allowed at the last minute? And why would Ann Taylor allow it? Maybe because she's like, well, it's better than having a rebuttal, because then we don't want to make, I mean, I'm just over here trying to figure out, like, why should this person even be allowed to testify at this point? Like, the only thing they had was DNA. I think there's a ton of chain of custody issues and like that. I don't think that the jury was ever going to see Linda Lane videos. I don't think the jury was ever going to see the video of 1112. The jury's never going to see that stuff. I showed you guys back a couple lives ago that the 1112 video, it was sped up during those 4 or 5 seconds, like badly. So here, thus the state retained Dr. Okay to review the DNA testing and the okay, I just read that. Okay, awesome. Based on Dr. Westring's independent analysis, Bryan Kohberger was excluded as a potential contributor for item 13.1. This motion was heard by the court on April 9th, 2025. The court issued an order on April 18th, 2025, ruling that the defendant's motion was denied as moot. And the reason it was denied as moot is because it's like, you have somebody that's there that's going to be testifying that he's excluded. On May 9th, 2025, the state sent the following proposed stipulation of facts to the defense for their consideration. A DNA sample taken from under a fingernail of Madison Mogan contained a mixture of DNA from 3 individual contributors, Madison Mogan and Kaylee Gonzalez. Were identified as 2 of the 3 contributors to the mixture. Defendant Bryan C. Kohberger was excluded as a contributor to the mixture. Now think about this. Why would Ann not stipulate to that? There's a reason. There you go. I was going to say, I swear when this all started, there was 4. Like, so now we're changing the number because it was Maddie and Keely couldn't be excluded, right? Of being 2 of the, I mean, I thought there was, is it possible of 4 mixtures? I don't know. That's what I was, and I think that it all goes then like ding, 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 ready. It's for the reason that Ann Taylor's team could not stipulate is there's one reason and one reason only. And that's because they said that multiple people committed this crime. Maddie's fingernails prove that. And with when they were going to bring up the Cole kid, they could not exclude him as being one of the, right? A month later, on Sunday, June 8th, 2025, the state emailed defense counsel regarding the proposed stipulation since the state had not received a response to the above proposal. On June 9th, defense counsel informed the state that they would not agree to the stipulation so that defendant could present testimony on the issue. And now it all comes full circle for me when I'm like, okay, yep, because of their theory of the case. And that's going to come in your case in chief, like when you are presenting your case, and that this was not done by one person, that this was done by 2 or more people. Or if they were just going to say 2, like, if your team isn't on it, right? And there's probably like Hitler over here is like, why aren't they just stipulating that? Like, it's fucking saying their fucking their client's excluded. And it's like, no, this goes to our whole presentation, which is that not beyond a reasonable doubt can you say that only one person committed this crime and that it was Bryan Kohberger. In fact, they got 45,000 tips. Okay. They're going to present this as if it was just one of those 45,000. So what would make this? That's why Ann Taylor was fine with saying, okay, yeah, no, you can use it as a general tip. Yeah. Because then it wouldn't come from any DNA. Right? What made you go down this path as to go get this guy's parents trash? Like, how are you going to answer that when you were getting these people's DNAs that you were actually having interviews with and you weren't even putting them in? You knew, I'm telling you, the coach that had his cell phone off and his DNA was never submitted. It was taken, but it was never submitted. Like, the majority of the people that gave up their DNA, it was never taken. It was never taken to the lab to be worked, like to have a profile worked on so that you can compare it to anything at the crime scene. The work that was being done in this case doesn't make it seem like it's like they already knew how the end was going to play out and that all of this was just whoop. So yeah, a month later on Sunday, June 8th, 2025, the state emailed, nope. Based on the above, it appears it may now become necessary for the state to call Dr. as an expert witness in the state's case in chief to ensure that the jury understands the state's position that defendant is not a contributor to the DNA mixture and also understands why the ISP lab's reported results were described as inconclusive. Do you understand that they should have thought about this before? So then my question is why was she okay with them using him in the case in chief? Why didn't she just object to being, oh, too bad, so sad. Guess you're stuck with Jade Miller. And so Bill's over. You guys think Bill wrote that? You guys think that's a Bill sentence? This is not a based on the above. It appears it may now become necessary for the state to call Dr. Westring as an expert witness in the state's case in chief to ensure that the jury understands the state's position that defendant is not a contributor to the DNA mixture and also understands why the Idaho State Police lab's reported results were described as inconclusive. You think that sounds like him? No, that sounds like an educated, persuasive motherfucker, and that's anything but Bill Thompson. Oh boy. That's a very like, oh. If the state cannot call Dr. Westring, the jury would be left with the misperception that the state sought to suggest that the defendant could be a contributor to the DNA mixture, which has never been its intent and would raise a variety of concerns under Idaho Rule of Evidence 403. I'm like, well, shouldn't you have thought about that when you did all the shit that you did with the grand jury? Do you guys see how nuts this is? This is like a huge, like, hey, Hippler, like, this isn't fair. Like, we don't think that he's the contributor of that. No, but you were fine with Jade Miller saying and whipping up some shit. Right? But why does it matter so much? When were those briefs due? This is writing this in hindsight after you've already seen the defense brief, because now you would have like their strategy. Like, and that's coming out in batch 2. I can't wait to read these briefs, these trial briefs. They basically outline your case, like how you're going at it. I agree. This case is becoming one big mind fuck. But I think it's because you have literally this defense team does not trust anything that not just the prosecution, okay? Because remember, the prosecution was also part of, like, they were involved in every aspect of this. They were writing up search warrant. You know, they were basically the investigators and the prosecution. I'm sorry. And I think people forget that, who haven't been following this case, that they were basically doing like police detective work. But the prosecution or the defense doesn't trust the prosecutors at all. And more importantly, they don't trust the investigators at all. And so therefore they don't trust, if you don't trust that, then anything that they're saying about this, yeah, go sit and spin. But there's reasons that they don't trust. It's not like, oh, I just don't trust you. You know, I hate to say that I was right, but I was right. I told you guys to listen. When you guys get to hear the interviews with the girls, I mean, everybody, you're going to see that these reports don't match the interviews. In Bethany's report, never mentions the masked man that Dylan told her about. Okay. And sure as shit doesn't say about anything about getting up at 11. Okay. Sure. I mean, everything that Blaker wrote, and he wrote it while he would have been the luxury of sitting there watching the tape, and he's writing the narrative that they literally wrote up for this probable cause affidavit that they did because they arrested him on the 29th. Blaker wrote up that report on the 28th of December, and he did that interview on the 13th. Pretty crazy, huh? I mean, maybe she didn't hear him say right. She heard him say left or something. But why didn't he write in his report the word right? That's the better question. Why is his report saying that he doesn't say that bedroom was to the right? It's really, really important because there's a jacket in that room. There was also a bed in that room. And but that jacket in that room to the right had blood on it. Don't know whose blood it is. I think Anne knows, you know, when you work for the prosecutor, when you are a prosecutor, you start learning the prosecution tricks, right? And so there is some advantage to actually having a defense attorney that was once a prosecutor. Trust. And also they have way better relationships with the prosecutors if they've, worked with people. When they were a prosecutor, they worked with those people. And so if you're ever in a situation that you need a defense attorney, it ain't a bad idea to see that they've had some years, or like what is it? One of like right here. The people that work for under the judges. But I don't know. So yeah, but Hitler saying that, or I'm sorry, Bill Thompson supposedly saying that, God, well, consequently, the state respectfully seeks the court's permission to amend the state's witness list to add, homeboy, and then Ann Taylor doesn't object. Now, this is the defendant's reply to the state's objection to the defendant's offer of proof, and this was unsealed. But see, like, we're going backwards in a way, so it's I really wanted that other document. But we can try. So Ann Taylor, this is a response to the state's objection to it. Just make sure that one wasn't. But that didn't come out yet. Idaho loves to work on Friday nights. I don't know why, but they just love it. Oh, got it. Oh, yeah. Here we go. Got it. Here, I'll just show you guys on the screen. So this is the state's objection to the defendant's offer of proof alternate perpetrators, and defendant's evidence in support of offer of proof. So, comes out of the state of Idaho by and through the Latah County prosecuting attorney and objects to the defendant's May 14, 2025 offer of proof, alternate perpetrators, and May 23, 2025 evidence in support of. On April 18, 2025, this court entered its order. And remember, it was like, yeah, no, you're not. Like, and it was like on page 6. In that order at page 6, the court directed that the defendant must present offers of proof no later than May 14th. So the matter can be addressed at the pretrial conference, which was scheduled for May 15th. The court recognized the Idaho Supreme Court's decision in State v. Meister. We all heard about that. Okay. The court correctly noted that, after all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. So the defendant subsequently filed his offer of proof, and that was on May 14th. And then there was a pretrial conference held on May 15th. The court directed the defendant to submit actual evidence to support his alternative perpetrator allegations, stating that the defendant's May 14th proffer contained allegations that were fairly objectionable. So the defendant subsequently filed his evidence in support of offer of proof, alternate perpetrators, on May 23rd, 2025, yet the defendant's proffered evidence is substantially no different than what the defendant alleged on May 14th. So it appears that in reality, the defendant merely wants to cross-examine various states' witnesses as opposed to trying to make a case of an alternate perpetrator. Now, check this out, guys. These on the witness list, okay, on the witness list, the state put on the witness list these 4 people that Ann Taylor and her team listed. They're actually they're under the lay witnesses for the state. While the defendant certainly has the prerogative to cross-examine states' witnesses, he cannot speculate that a third party committed the crimes with which the defendant is charged. This is the essence of the limitations and requirements related to alternate perpetrators. It remains the state's position that any attempt by the defendant to offer or argue an alternate perpetrator theory without evidence specifically connecting persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury, and would also result in undue delay, waste of time, needless presentation of cumulative evidence, and unfair prejudice to the state. Turning next to the 4 individuals the defendant wishes to argue as alternate perpetrators, the state addresses each in turn. As discussed below, the court should preclude alternate perpetrator evidence as to each because the defendant has not provided admissible evidence linking them to the homicides. So this is this first person. The defendant first proffers proximity to 2 of the victims hours before the homicides without something else later that night is not probative evidence and is excludable under Idaho Rules of Evidence 403. So the defendant, so this person right here, the defendant first proffers, and then that's redacted. And it says proximity to 2 of the victims hours before the homicides. Okay, this is either going to be Jack Showalter or it could potentially be Jack Showalter, Decor, or that Cole kid. The defendant next points to 3. Okay, I'm sorry. Particularly looking at, and then it was blank, 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 blank. The defendant next points to 3 lab reports, which merely reflect that as part of blank blank's cooperation with the investigators, he voluntarily submitted a DNA sample and fingerprints. Okay, so Jack Decor did that. Jack Showalter did that. And I think that Cole kid did that. So like those 3 people are still like on my radar here. Tellingly, the defendant fails to note that the Idaho State Police Forensic Lab eliminated, I'm telling you, I think this is Cole. But whatever. But whoever it is, they eliminated the DNA from the crime scene. Blank, this person's DNA was not found on the knife sheath strap on which DNA was found that was matched to the defendant, or in the DNA mixture found on the back of the sheath. So check this out. That means on the back of the sheath, the mixture is not Bryan Kohberger's. So the sheath has an unknown male mixed with the what? 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 Again, it's getting late, so let me just make sure I read that again. This person, they're redacting here, blanks, DNA was not found on the knife sheath strap on which the DNA was found that was matched to the defendant, or in the DNA mixture, the strap. I thought it was on the button part. What? So it was in the inner part? It was on the strap part? Anyways, or in the DNA mixture found on the back of the sheath. Holy shit, I read that right. Oh my God. Oh my God, I read that right. What is going on here? Well, a strap has the, when I'm talking about the strap, like, is it considered the strap when once you pop it and it's hanging? Is that a little strap? Because then like there's a button that's part of the strap. No? Well, it's official. There is mixture DNA, not Bryan's, on the sheath with the victim's blood. Oh, dear Jesus. Okay. So, but I mean, it makes sense what they're trying to say is that, well, that person's, it's not even in this spot, you know? Again, Blank's DNA was not found on the knife sheath strap, and then in parentheses, on which the DNA was found that matched to the defendant. Or in the DNA mixture found on the back of the sheath. Now, which way was the sheath laying when it was laying? What this means is that there's somebody else's DNA is mixed in with the victim's blood that's on the sheath. So remember how we always knew, remember Hitler was like, don't bring up the blood. Remember it was about, don't bring up that mixture, don't bring up the blood, don't talk about that. This is what that was about. Back when he said that. Because there was A, B, C, and D. What does this say? No, Lana. It means they never had his DNA. Lana, it's queer. What the fuck is that? I just had to highlight that. Can I have a shot of sake after that? Huh? Huh? What? Can I have a sake? What the hell is going on here? Who the fuck is writing the word queer? Knock it off. Silly faggot. Dicks are for chicks. Come on. No, I can't see. It's so dark. Cheers. Yes. Crime Con, motherfucker. Oh my God, we're going to Crime Con in the morning? What time's the flight? What time's the flight, Julie? Julie just came in the chat. I was wondering who was blowing up my phone. $10:45? It's not bad. I can do that. Fuck. Why do you guys get me into this shit? All right, I'll do it. See how easy that was? Just like a Sunday night. Just like prom night, baby. Okay. Yes, let's go, Anna. You're going to get... I was like, what the fuck? I don't even know what's going on right now. All I know is I'm literally blown. I am literally blown to bits at what I just read. And then I'm getting asked to go to Crime Con. Bella's over here like, she's like, we're leaving in the morning. We're going to Crime Con. I was like, I fucking hate Denver. I hate Colorado. Fuck that place, man. Are we staying at the Gaylord Hotel? Can we be gay at the Gaylord Hotel? We're doing sakis, queers, and silly rabbits. It's clear, Lana. I'm only going if Nancy Grace can just come in my bed with me. Oh my God. Can you imagine having sex with that woman? She'd be like screaming like, ah! Come on now. Oh shit. Okay, focus. I can't even believe this. Who doesn't go to trial with this? Okay. See States Exhibit S1 ISP Forensic DNA Lab Report 4. Yeah, I'm going to need to see that motherfucking lab report. ISP Lab Report 7 excludes blanks DNA from the swab taken in Xana. There's something in Xana's bedroom? And from the DNA from under Maddie's fingernail. See States Exhibit Report 7. Okay, I'm waiting. I have 46 reports coming from the Idaho State Police Lab. ISP Lab Report 13 excludes blanks DNA from the samples from the fingernails of all the other victims, as well as swabs taken. Well, that doesn't matter because Bryan Kohberger isn't under them either. You know what I mean? Like, it does matter. I think about. I don't fucking know. This is crazy. What a lie, Lana. Julie. I saw a firecracker under my door and somebody was just coming around and they were just putting lumen all over the place. Okay. So everybody's saying that this person had, like, I don't know, gloves on. So this is foreign DNA though. Because if they took a bunch of DNA from the people that they all know and it still didn't match to like that blood that's in there, like whose DNA is in and mixed with the blood that's on the fucking knife sheath? I'm telling you, I don't believe that they checked the coaches. What's Julie saying? Great, ready, lady. Wait, Julie, come on. Oh my god, the upper floor banister, and the bottom of the handrail. Was there anything there though? Idaho State Police Lab Report 26 excludes this person's DNA from a sample taken on the north wall of the stairwell at the residence and another sample taken from the half wall at the residence. Idaho State Police Lab Report 31 excludes this person's DNA from the sample taken from the door of Miss Mogan's bedroom. What? Wait, what swab? The DNA, Blank's DNA from the sample taken from the door? Whose DNA is on the door of Maddie's bedroom? The defendant next submits 3 law enforcement investigative reports. And they named these numbers. First, these reports and their contents are hearsay. Okay. That said, all they demonstrate is that blank affirmably reached out to law enforcement investigators and voluntarily cooperated with them, including providing his DNA. Defendant's speculation that this somehow suggests culpability is without foundation. The balance of the defendant's submissions are comprised of references and then blank. In sum, the state respectfully submits that the defendant's submissions regarding this person do not even rise to the level of mere inferences that he could have committed the crime, much less evidence, direct or circumstantial, linking him to the actual. Okay, the defendants continue with regard to this person and are inadequate in the same ways as discussed with respect to that person. Blank's DNA was excluded from the mixture on the back of the sheath, 1, from the sample from Xana's bedroom, 3, from the sample found under Maddie's fingernails, from the fingernails of all the other victims, and from the swabs taken above the stairwell at the residence. Oh, that's the other blood that's there. That's right. The upper floor banister and the bottom of the handrail at the scene of the crime. Blank's DNA was also excluded from the swabs of north stairwell. Defendant next alleges that Blank's alibi as to his whereabouts and activities on the early morning of 13th cannot be corroborated. Holy shit. Offer of proof at this is incorrect. Blanky. Defendant next suggests that blank. This is not probative of a connection between Blank and the crimes. As he did with Blank, defendant then cites, quote unquote, many tips that Blank should be considered a suspect. Yet there is no evidence of any, quote unquote, tip, which would be hearsay anyway. Well, that's what you guys just stipulated to a hearsay. I mean, this is crazy. In the defense valuing other than statements attributed to Blank. The balance of the defendant's submissions regarding Blank, as with the others, are largely hearsay and are at best mere inferences that Blank could have committed the crimes. There is no evidence directly linking. Okay, wait a second here. You know what that means? This person's DNA was not tested. And I think this is the coach. I don't know why. I have no idea why. But I don't think the coach ever had an alibi. Whoever this bottom person is, I don't think it has any. Why aren't you talking about that their DNA? Like, you didn't test the DNA. Who would this be? Right? Wouldn't you be writing that? And now this person, defendant next refers to this person, as with blank, 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 DNA was excluded from the strap at the back of the knife sheath. Well, then whose fucking DNA is on the back of the strap of the knife sheath? Okay, let's talk for a second here. Let me get this straight. Bryan Kohberger, Bella's always said to me, hey, he wiped that fucking thing down. He just didn't fucking wipe off the button. That's what fucked him. And I'm like, okay, well, guess what? You're wrong. Because there's DNA on in plain sight. There's DNA actually on other parts that aren't the victims. And if you're saying that he wiped it all down, then it would have come after the wipe down, which is during the commission of the crime. I just like to tell Bella she's wrong sometimes, you know. Sample C has always been left out. Sample C is because it was mixed in with this. Why couldn't True Allele? Did they separate it? Did True Allele come in and separate them? AT would be offering a lot of hearsay under the exception that not being offered for the truth of the matter is. Yeah, it is. This is unbelievable. All right, guys. Then you should all be asking yourselves, who the fuck would take a plea deal when you have all of this? This is crazy. So think about this from like a parent standpoint. If you find out about this for the first time and you find out, oh my God, wait, there's DNA that was mixed in with my kid's blood that's not Bryan Kohberger's. It was mixed in with Maddie and my kid's blood, right? And it's not Bryan Kohberger's. Well, then whose is it? And all the DNA that you took in, well, then whose is it? Lana, I'm going to call you right now. We're talking about damn DNA and blood. All right, I'm going to end this anyways. I just saw your message. I'll be calling you. Give me 2 minutes. I'm going to be rounding this up. Gosh. It's Wendy Adelson's definitely. You know, when you think about it, it's like, do you think, I don't think the Guns office is doing anything about this. Don't worry, I'm not giving up yet, guys. We have to finish the report. So the defendant next refers to blank, as with blank by blank, DNA was excluded from the strap at the back of the knife sheath. See States Exhibit S1. Okay, yep. In addition, blank was excluded from the samples taken from the victim's fingernails, and then wanted to exclude all of this from the swabs above the, okay. Why does that part have to be? What the fuck? That's interesting. Excludes from the swab taken of the north stairwell. Okay. Lab report thermos used blank DNA from the sample taken from Maddie Mogan's bedroom door. Maddie Mogan's bedroom door. That's interesting to me. The defendant notes that blank was familiar with the victims and their residents and lived nearby. Aside from the fact that blah, 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 the other observations of proximity are not unique to blank. Indeed, it appears that there were numerous people who were familiar not only with the victims but also the residents. Defendant also makes note that blank, 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 blank. This too is not suspicious. Blank, 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 blank. Wait. The defendant also alleges, like, why does all this have to be fucking redacted? This person was fully cooperative with the investigators, providing DNA and consenting to blank. Again, the defendant's allegations do not rise to the level of an inference that blank committed the crimes or the murders, much less constitute evidence. Finally, the defendant submits blank as an alternate perpetrator. The defendant attachments clearly reflect that blank was cooperative and voluntarily submitted a DNA sample. ISP lab reports 13 and 31 exclude blank DNA from any of the samples from the crime scene or the victims. Inconclusive as to the sample from Miss Mogan's fingernails. I think that's that cool kid. See exhibit ISP lab report 26. Also blanks DNA from the sample of the north wall of the stairwell. Blank's only possible connection to any of the victims was blank, 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 blank. This behavior is not probative of any role in the homicides and is also excludable under 404. 404. 404. Defendant also alleges that regardless, even if this act does not provide any evidence of a connection to the crime, much less the type of evidence required under the balance of the defendant's proffering regarding blank are largely hearsay, and some would be also precluded by 403. That means like his past behavior. What's this person's past behavior? Prior bad acts. Who the fuck is this dipshit? Who is this non-law abiding citizen? Perhaps the most obvious failure of the defendant's proof is the fact that once again, why can't they put why is this? Once again, the defendant's submissions do not even rise to the level of mere inference that blank could have committed the homicides, must let a direct link. Defendant's submissions does not connect the name alternate perpetrators to the crime scene. In addition to the foregoing, none of the defendant's submissions even hint at any connection between these four individuals and the defendant himself. Based on the undisputed evidence and what appears to be his theory of the case, the defendant likely will argue that the true killer or killers committed these crimes and also framed the defendant by placing his K-bar knife / sheath at the scene. But nothing in the defendant's submission points to any of the alternate perpetrators accomplishing this or having the motive or means to do it. Nor does the defendant connect any of them to a K-bar knife, whether the one the defendant purchased in March of 2022 or another K-bar. Defendant's submissions also do not connect any of the individuals to a Hyundai Elantra. Yeah, because that car killed people. Sorry, that's crap for me. They knew that car existed and were still literally hunting down poor little Jack Based on the above, the state respectfully prays for an order from this court prohibiting the defendant from arguing an alternate perpetrator theory. The defendant is free to cross-examine these individuals if they are called by the state, but again, should be barred from suggesting or arguing that any of them are the alternate perpetrators of the homicides. Again, William did not write that. Sorry, but he just didn't. Okie dokie. Well, with that said, gives you a lot to think about. I want to say thank you for joining. Okay. I do want to say this, though, because I can't just leave it like a cliffhanger like this. I'm going to read this. Whether rooted directly in the Due Process Clause of the 14th Amendment or in the Compulsory Process or Confrontation Clause of the Sixth Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. And that's Crane versus Kentucky. The error excluding such evidence is reviewed de novo on an appeal U.S. Shryack. Due process rules trump evidentiary rules. U.S. versus Lopez Alvarez. When reserving its ruling on the state's motion in limine, alternate perpetrator evidence, the court stated, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. The state has listed blank, 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 blank as trial witnesses. The state has also disclosed and labeled exhibits that it intends to use at trial, which include the names or actual video of these witnesses. There's video of them. These exhibits include blank, 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 blank. Each of these alternate perpetrators identified by defendant and listed as witnesses by the state are more closely tied in knowledge, opportunity, and possible motive to the crime than Mr. Kohberger. All four of the alternate perpetrators are linked circumstantially or directly to the crime. Moreover, given Mr. Kohberger's expert disclosures that more than one person committed the crimes, other evidence supports the defense's theory that Mr. Kohberger is not the person and the crimes are committed by more than one person. Defendant's offer of proof in part arises from the state's motion limiting alternative perpetrator evidence filed on February 21st, 2025. On page 2 of that motion, the state argued in quotes, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. While it is true that there are thousands of tips, somewhere in the range of 45,000 to 75,000 tips, and they continue daily because there's fucking idiots out there that keep fucking sending these tips to the fucking police, the state has chosen to present evidence of investigations into the specific named individuals and the conclusion that the state has ruled out these possible perpetrators. The state's purported diligence in ruling out possible perpetrators, especially those with who close connections to the victims, is an issue that the state is putting front and center at trial in its own case in chief. The court cannot consider or weigh the strength of the state's conclusion that a suspect has been cleared in deciding if the defendant's evidence is admissible. Forensic evidence existed, but could still be refuted by third-party perpetrator evidence of a person in the neighborhood. It was reversible error to exclude it. That was Holmes versus South Carolina. Wow. Mr. Kohberger has the right to confront this evidence. The state argues that the evidence submitted in the offer of proof is inadmissible. As explained above, much of it the state seeks to admit in its case in chief. So how are you going to sit here and say it's inadmissible? So then you're opening the door. Or you're not even able to use it. More importantly, in Chambers versus Mississippi, the United States Supreme Court held that a defendant's constitutional rights to a fair trial and to present a defense sometimes require admission of evidence of third-party culpability, even in the face of evidence rules that would or could exclude it. Hearsay may be admissible in such cases because the 6th and 14th Amendment rights to due process, to confront and cross-examine witnesses, and to call witness is never precluded. Fairness and trustworthiness of the evidence are important. They sure are. Mr. Kohberger's proffer includes details that allow this court to see that there is trustworthiness to his basis for naming 4 alternate perpetrators. The police reports and tips submitted as exhibits in the offer of proof are documents that provide basis to show a link to the case that is more than speculation and grounds that explain the subject of cross-examination or direct examination of witnesses. While the tips themselves may be inadmissible, they are evidence that this court must consider in determining if there is a link and more than mere speculation. When evaluating alternate perpetrator evidence for case link or nexus, some courts demonstrate a willingness to admit purely circumstantial evidence that a third party committed the crime. Some courts hold that even, and that is U.S. versus Stiver, some courts hold that even when the state's evidence is purely circumstantial, the third party culpability must clearly point to a specific third party, i.e., in quotes, some act connecting the alternate suspect to the crime. They list a bunch of different cases I'm not going to read. The Ninth Circuit noted that evidence at Jones' murder trial was primarily circumstantial in nature and concluded that the state trial judge erred in excluding Jones' circumstantial evidence that an alternate suspect committed the crime. Whether direct or circumstantial, all of the alternate perpetrator evidence proffered by Mr. Kohberger has both specificity of person and connection to the crime. So my question would be this. Nobody did IgG if they were able to separate and get that profile. Were they able to separate and get that profile? It's a single source. Well, it's not a single source, but it's that male profile. It wasn't able to be separated, and like True Allele didn't do that. That's what True Allele is known for. And then nobody did IgG on that male that's mixed in the blood on the sheath of with the victims. Does that make sense to you guys? I mean, I would. I'd be like, with respect to blank, it's all redacted. With respect to, this is not a thorough investigation. This is not suspect elimination, as the state argues. They didn't eliminate shit. Okay, now that I've read this shit, yeah. Mr. Kohberger did not produce these suspects. The state did, and in some instances, continued to investigate them or simply stop their investigation, ignoring evidence that there was more than one perpetrator. Prosecutor fucking Bill Thompson said he could not rule out 2 perpetrators from the very beginning. And then they cite that interview that he gave. What dumbass. I knew he should never done that. Why did he, though? One should wonder. Mr. Kohberger's offer of proof was not an exhaustive list of all the evidence disclosed in this case that points to the 4 alternate perpetrators. In fact, the state's opposition disclosed blank, 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 blank. By listing these alternative perpetrator names on their witness list, and by listing various exhibits on their exhibit list which pertain to these individuals, the state has opened the door for Mr. Kohberger, I knew it, to confront this evidence and cross-examine state witnesses. But that means it has to come in, though. Mr. Kohberger suspects that the state has listed the 4 alternate suspects as a ruse to make it look as if they will put the 4 males on the stand to deny their involvement. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but instead use lab reports to portray elimination, the door is open to confront that evidence, and Mr. Kohberger should be allowed to call the alternative perpetrators and other witnesses to show their connection to the crime. How each piece of evidence becomes admissible at trial depends on how the state offers it, triggering Mr. Kohberger's right to confront such evidence. Mr. Kohberger must be allowed to develop this evidence, and a ruling excluding or limiting this area of inquiring at this point would be premature. The United States Supreme Court ruling in Chambers allows for the admission of the evidence. The state agrees at a minimum to this confrontation in its objection. This court should allow Mr. Kohberger to present alternative perpetrator evidence. Well, don't worry, guys. Dateline will leak the four alternate perpetrators. Trust. All right, guys, there you have it. Use the comment section of the video. I gotta know what you guys think. Even if your comment just says 1, 2, 3, 4, I would love to see who you guys think these 4 people are. We're all allowed to throw out our opinions. I don't believe that is harassing in any type of way. If you carry on in the comment section, though, about shit that just doesn't fucking matter, yeah, I'll just be deleting that. But I'm just curious who you think these 4 people are. Anything else you think that is educational for us to consider with what you heard tonight, put that in the comment section of the video. Thank you to the moderators. Lot to soak up. If you did not see, Bethany's interview was released. Go back and check it out. Plunder put it out. We use that video. Cheers to Paula. And if you keep messing with Paula, make. All right, guys. Till next time. Peace out.